Welcome to Module 4. We are not discarding the ethical frameworks you learned in Modules 1 through 3. Instead, we are taking those exact same principles and applying them to unfamiliar environments. Our objective is to map out how different roles in the justice system operate under uniquely tailored ethical constraints, from a local courtroom all the way up to national security operations. This diagram illustrates the bedrock of the adversarial system. The premise here is that justice is best served by the rigorous testing of evidence through direct opposition. Take the defense attorney. Their practice requires absolute attorney-client confidentiality. This is a systemic necessity, not a professional perk. If a defendant believes their lawyer will disclose their secrets, they will hide the actual facts of the case. Without absolute candor from the defendant, the attorney cannot mount a defense. The adversarial test fails, and the system loses its legitimacy. Looking at the prosecution side of this matrix, the prosecutor carries a distinctive obligation to seek justice rather than simply achieving a high conviction rate. This mandate includes the Brady Rule, which is the constitutional obligation for prosecutors to turn over any evidence that is favorable to the defense. For students working in law enforcement, handing over evidence that actively weakens your own case often feels counterintuitive. However, it is a strict constitutional requirement designed to prevent wrongful convictions. Prosecutors face specific occupational hazards regarding this duty, primarily the temptation to overcharge defendants to force plea deals and the illegal suppression of evidence. If left unchecked, the systemic incentive to win cases distorts a prosecutor's ethical judgment. On the other side, the defense attorney holds an opposing mandate. They are required to provide zealous and competent representation to all clients, even those who are factually guilty. Without a zealous defense aggressively challenging the state's evidence, the burden of proof becomes meaningless and the fairness of the entire process collapses. At the apex of this triad sits the judge, bound by the strict obligation of absolute impartiality. This neutrality requires recusal. A judge must step down from a case if there is a genuine conflict of interest. It also strictly prohibits ex parte communication. A judge cannot communicate with one side of a case without the opposing side present. Beyond formal procedural rules, judges must navigate psychological risks, specifically the danger of implicit or unconscious bias. This bias is most dangerous during highly discretionary phases of the justice process. Setting bail amounts leaves significant room for unconscious assumptions to dictate whether a defendant waits for trial at home or in a cell. Sentencing is the other major discretionary phase, where unchecked implicit bias drives systemic inequity. If the judge's neutrality is compromised by either formal ethical conflicts or unconscious bias, the adversarial system devolves into a rigged game. Moving into the post-conviction environment, we see 5 branching paths. How a society chooses to punish dictates the environment its officers work in. These represent the 5 rationales for punishment. Retribution punishes for its own sake. Deterrence aims to prevent future offenses. Incapacitation removes offenders from society. Rehabilitation treats the underlying causes of crime. Restorative justice focuses on repairing harm to victims and the community. Emphasizing one of these rationales over the others reshapes the entire physical and policy architecture of a correctional system. A prison system built purely for incapacitation looks and operates vastly differently than one designed around rehabilitation. The correctional officers operating inside these facilities face an elevated ethical risk profile. The environmental factors are unique. Officers operate in a closed setting with extremely limited public visibility. They maintain near total control over the daily lives of inmates, creating a massive power imbalance highly susceptible to abuse. These officers face harsh occupational realities, including chronic understaffing and a heavy psychological toll. Daily exposure to violence compounds these environmental stressors. While these severe occupational stressors are real, they can never be weaponized to excuse ethical misconduct or the abuse of authority. Out in the community, probation and parole officers operate under a dual mandate. They face a central tension, the requirement to strictly enforce the law while simultaneously supporting the offender's successful reintegration into society. Consider an officer discovering a technical violation, such as a missed curfew. On the enforcement side, strictly applying the rules for the curfew violation could trigger immediate reincarceration. On the support side, reincarceration destroys the hard-won employment and housing stability the officer is actively trying to help the parolee belt. Pulling back to the macro level, we see a similar tension in national security and counterterrorism. This sliding scale illustrates the counterterrorism paradox. The surveillance tools that make prevention most effective carry the greatest risk of civil rights abuse. Serious, good faith positions exist on multiple sides of this debate. Balancing security and liberty yields no easy default answers. Looking at the entire system, the core insight of this module comes down to one case, three roles. In a single trial, a prosecutor, a defense attorney, and a judge can all act with perfect ethics, even while aggressively pursuing entirely different immediate objectives. This specialized friction is a deliberate design feature of the adversarial system. It is not an ethical contradiction. The midterm examination covering modules 1 through 4 closes at the end of this week. Proceed to the next section in the module to begin your review.